Good afternoon. My name is Zachary Hyman, and I'm currently serving as the chair of the State and Judicial Liaison Committee of the Business Law section of the Florida Bar. Today, we have the unique pleasure of providing you with some new programming concerning what's going on with our court system and what we expect to be happening in the near future. One of the unique positive aspects of what has happened with the COVID-19 crisis is modernize the way that we can practice law, allowing attorneys to very frequently participate in hearings by video conference. And also, more importantly, it has enabled us to participate in courts and hearings across the state of Florida. To that end, we've reached out to a series of judges who are located throughout the state to provide you with updates as to what is going on in their courts, answer a few questions as to what they're seeing, and time permitting, answer questions from you as the participants and attendees of this matter. If you'll look at the bottom of your screen, you'll see that there is a Q&A button. That Q&A button enables you to type in a question, which, if we have time, will enable us to ask the judges or the judicial panel questions that you may have. If we don't have time to answer or get to these questions, we'll hope to, at another subsequent program, get to them there. In addition, in about 2 or 3 weeks, the Business Law section will be hosting another similar program where we will be hearing from federal judges about what is going on in federal court as it relates to the COVID crisis. And if there's interest, we'll have a final third session where we will answer the questions which have been posited to the group. Before I start introducing our esteemed panel, I'd like to also thank the members of the State and Judicial Liaison Committee that made this possible. Specifically, I'd like to thank Judge Lisa Walsh, Judge Thomas Smith, Keith Bell, Amir Isaiah, and Dietrich Saul. In addition, it would also be incumbent on me to encourage each and every one of you to take on a pro bono case, as it will help benefit and elevate the bar and the practice in Florida. As it relates to our panelists, I'd like to start by introducing Judge Lisa Munyon. Judge Munyon is a judge of the 9th Judicial Circuit Court of Florida. More importantly, she's the chair of the work group on the continuity of court operations and proceedings during and after the COVID-19 crisis. In addition, she is the chair of the Florida Courts Technology Commission. This enables her to have a very unique perspective as to what's going on and how the courts are changing. Next, we have Judge Melanie May, who currently serves in the 4th District Court of Appeal. And she is also currently a member of the Post-Pandemic Planning Appellate Courts Work Group, which is one of several groups that are part of the National Center of State Courts, Conference of Chief Judges, and Conference of State Administrators and State Justice Institutes initiative. The purpose of this committee is to discuss how courts are adapting to the challenges on a national basis presented by the COVID-19 crisis. Next, we have Judge Jonathan Sjostrom. And although I have to candidly admit my biggest fear was brutally mispronouncing his name, he also serves as the Chief Judge of the 2nd Judicial Circuit and is currently the chair of the Chief Judges Committee in Florida. Next, we have Judge Donald Myers, who is currently the Chief Judge of the 9th Judicial Circuit. After that, we'll hear from Judge William Thomas of the 11th Judicial Circuit in for Miami-Dade County, who also serves as the Complex Business Division Judge. And finally, is Judge Jack Tuter. In addition to the fact that I have had the pleasure of appearing in front of Judge Tuter on several occasions, he is the Chief Judge of the 17th Judicial Circuit and is also currently the Judge of the Complex Business Division in for Broward County, Florida. This panel we have hand-picked based on their knowledge and expertise in this field, and more importantly, in their passion for the practice of law and elevating our profession. So first, I'd like to hear from Judge Munyon as to what's going on with respect to the courts and the continuity panel.
Good afternoon, everyone. It is an honor to be here. Thank you for inviting me, Zach and Stephanie. I appreciate it. First, it would be remiss if I did not encourage all of you to go to the Florida Supreme Court's website. If you're wondering what the current state of affairs is statewide with regard to administrative orders governing the courts, if you go to their homepage, you will see at the top of the homepage a banner that's brownish in color, and it says statewide advisories and orders. If you click on that link, it will take you to a page that has all of the statewide administrative orders that deal with the COVID-19 crisis. And there is a lot of information there that would assist you in understanding what's going on in the various courts throughout the state of Florida. As all of you know, it seems like it's been longer, but on April 6th of 2019, the Supreme Court entered AOSC 20-23, and that suspended most proceedings in the state court system and suspended some rules. On the 21st of April, they created the work group that I chair, and they identified 4 phases of this pandemic. Those 4 phases are pretty easily understood. The first phase, which is the phase that was instituted on April 6th of 2019, was in-person contact is inadvisable, court facilities are effectively closed to the public, and in-person proceedings are rare. The second phase is limited in-person contact is authorized for certain purposes and or requires use of protective measures. The third phase is in-person contact is more broadly authorized and protective measures are relaxed. And the fourth phase is COVID-19 no longer presents a significant public health and safety risk. So all of the circuits until recently were in phase 1. The work group worked on requirements and benchmarks to enter from phase 1 into phase 2. Those were adopted by the Supreme Court on May 21st via AOSC 20-32. And it did set the initial requirements for entering phase 2. An amendment to those requirements was issued yesterday in an amendment to AOSC 20-32. All courts at this stage in the state of Florida are either in phase 1 or phase 2. There are no courts that are in phase 3. Those benchmarks are upcoming. For a court to begin jury trials, a court has to be in phase 2 for 30 days. Pursuant to the Supreme Court administrative order. And when a court enters phase 2 and allows more people into the courthouse, masks are required. Public entering the courthouse is required to be screened via the questionnaire that's become pretty widely used throughout the United States, and temperature checks are required in phase 2. So those are all things that you can expect to see when you go to your local courthouse for the limited in-person proceedings. The court has continued to encourage and require, quite frankly, in many cases, remote proceedings. And I think most of you are probably participating in those remote proceedings as we speak. So that is the current state of affairs with regard to COVID-19 in the state courts.
Thank you, Judge. In addition, you're, as the chair of the Florida Courts Technology Commission, do you have any updates as it relates to the Zoom licenses and the continued use of Zoom with respect to the court?
That is not as much a Florida Courts Technology Commission question as a Trial Court Budget Commission question. But the Trial Court Budget Commission has authorized licenses, has authorized money to procure licenses for Zoom for judges around the state. Different circuits are using various technologies depending upon what's available in their area and what their infrastructure will support. But many courts are using Zoom and using it successfully.
And the final question before we move on to Judge May is, as it relates to pro se filings, how's that the courts are providing unrepresented people with access to the courts when they can't physically go in and file something themselves?
Well, I think most clerk's offices have established a procedure to receive filings from pro se litigants that are not filing electronically. They can still file by mailing to the clerk, but all pro se litigants can sign up for an account at the statewide portal, and they can e-file documents and receive served documents through the portal just like attorneys. We have a lot of pro se litigants that have taken advantage of that opportunity. I checked, and as of the end of May, there are 176,000 pro se litigant accounts with the portal. Now, they may only have one case that they're filing on, but there are more pro se litigant accounts than there are attorney accounts at this stage. Last month, there were 11,040 filings from pro se litigants. So we are getting filings from pro se litigants, and I hope that we will get more and encourage that more in the future, because I believe that they will get their orders more quickly and at the same time that the attorneys get them if they're on the portal, as opposed to having to wait for the mail.
And do you know if in phase 2 or phase 3, the courts will require across the state temperatures to be taken when people have appear or approach the courts?
Yes, in phase 2, temperature taking is required for everyone that is coming into the courts.
Thank you. Next, we have Judge Melanie May, who's currently serving on the 4th District Court of Appeals.
Hi, first let me thank Mr. Hyman for inviting me to participate in this webinar today, and also thank all of you who are participating, as well as those who are watching. Hopefully we'll be able to give you some information that is useful. Just to give you a little synopsis of what happened in our court, by the nature of our court, we were much more fortunate than the trial courts, and we really didn't miss a beat. First of all, most of us are able to work remotely and have been doing so for several years. So we had the technology available to us to continue working even though we were quarantined. We were prohibited, and in fact, those of us from Broward were immediately prohibited from entering into the courthouse. And then as the orders came down from the Supreme Court, we were all told to stay at home and work remotely. So all of our staff has been doing that, with a few skeletal staff that are in the courthouse. In the clerk's office, there are 3 clerks that work each day in the courthouse, and the rest work remotely. And the marshal's office has a skeletal crew as well. So they have been the only ones in the courthouse up until about 3 weeks ago, when the judges were then permitted to return to their chambers for limited purposes, but were required to use the same kind of masks and use the same kind of techniques. You were to go directly to your office, do not stop go, or do not pass go, and do not collect $200. Just go to your office and then leave from there. Other than that, the very first week of oral argument was done by telephonically. The second week was the week I was sitting. We only had 2 cases, which were really, we were able to resolve without oral argument. By the 3rd week, we were on Zoom doing oral argument and have been since. So we have not missed a beat on anything. Unfortunately, I think our court also, because of its technology implementation, was really able to get up and running faster than maybe some of the others. But everybody is doing that now. I don't know if you want me to address the work group I'm on at this point, or wait till later.
Yes, please. If you wouldn't mind addressing the work group as well, that'd be great.
So through the National Center for State Courts, I was asked to participate in this post-pandemic planning. And I think one of the things that came about is, I don't know that any of us were exactly ready. And so we kind of had to shoot from the hip and get ourselves up and going as soon as possible, which meant that a lot of us did things a little bit differently than others, while there was some commonality in some of the processes that we employed. So on my work group, which is just for the appellate courts, we have the Chief Justice from the state of Washington and the state of South Carolina. We have the trial court administrators from Idaho, Louisiana, and Indiana. And so the first thing we did was to collect information from all the courts around the country on how they staffed during the pandemic. And they're not widely different, but there are different staffing patterns that have been used. So we were collecting information. The idea is to ultimately come up with perhaps a best practice for that. The second thing we did was to collect information how each of the appellate courts, intermediate and Supreme Courts, were operating during the pandemic, both for oral argument purposes, for bar passage activities, and again, the staffing, how they use Zoom, whether they use Zoom or WebEx, or they use some other means, how they conferenced. And so once we collected all of that information, we've come up with it's called a remote oral argument checklist for justices and judges, taking the best that we have from across the country, and that will be a product of this work group. We were asked to do 2 immediate products and then 3 long-term products. So the 2 interim projects are the staffing and the checklist for oral argument. Along with that, we created a survey that will be sent out, because now what we want to know is, all right, we did these things all these different ways. What worked? What didn't work? What would you change? How would you do it differently? And in that vein, we also are asking questions about how has it affected the budgets of the courts? You know, have they had to get additional money? I was on a conference call yesterday. Pennsylvania just took a 15% cut across the board in their justice system. So we're collecting that data as well to see what kind of effects there were. Of course, there were some savings too along the way. So we're collecting that information with the idea to have 3 long-term projects. And the 3 long-term projects consist of a case conferencing as a remote working environment, and the deliverables will include an issue brief with a comparative analysis identifying the pandemic's effect on conferencing and evaluating the effective techniques that we've used to address them. The second item will be the central staff attorneys and chamber staff, how they were affected and how they were able to get their work done. And the deliverable will be a reference document with lessons learned and an action plan with descriptions of effective practices. And the third item will be a formation of a group of chief justices and state court administrators. And here the issue is a little more dicey as I've listened to the discussions, which is what authority each chief justice has in various states to make plans and order people to do things, as opposed to the legislature or the governor. And so it's got some interesting little constitutional aspects to it that I think will vary from state to state, because we vary widely on how we're created, whether we're elected, whether we're appointed, whether the legislature appoints the chief justice. So there's a lot of differences in the various states. So those would be the 3 long-term deliverables. The State Justice Institute, the whole collective group has put in an application in order to help fund these deliverables. And then there are other small, different work groups. There's a technology work group, the trial court work group. There's about 5 different work groups that are working in specific areas, and they have a variety of different deliverables that they will be providing. So that's kind of the work that we're doing right now. Does that answer your question?
Yes, it does. Have you guys discussed at all how to create a balance between allowing appearances by video conference and avoiding what's often called Zoom bombing? So on one hand, you have the public has an absolute right to access judicial proceedings, view them, everything else. But on the other hand, you don't want people who are trying to disrupt the process to jump into the oral argument. Has there been any discussion as to how to create a balance between those two issues?
Yes, and I want to applaud our IT people at our court. So the way we have handled that is the oral argument, as far as the lawyers and the judges are concerned, are done by Zoom, but we live stream to the public. So they're completely separate. We have waiting rooms, and we only allow the lawyers for each case in at the time of their particular case. And that way we've been able to control and prevent what you just talked about. There were some interesting news articles in the beginning of all this about flushing toilets and other kinds of things. So we've been able to avoid that. We have had a couple of blips along the way, but that's why this checklist for the justices and judges includes that kind of information. So it's really the lessons we've learned along the way and how to make sure that public has access to what we're doing. And we also have the ability to make sure that things run smoothly from the court standpoint.
Thank you very much, Judge May. Next, we have Judge Sjostrom, Chief Judge of the Second Circuit.
Thanks so much. So I'm John Sjostrom, Chief Judge of the Second Circuit. Second Circuit consisting of 6 counties served by 16 circuit and 10 county judges covering a geographic area the size of the state of Connecticut. 3 of the 5 smallest counties in the circuit, including the smallest county by population, Liberty County, home to 8,500 registered voters. Jack and Don have buildings with more people in them than some of my counties. So our experience has been interesting. The north part of the state has fewer cases, which is a mercy, but that has not stopped us from having some real serious scares in our courthouses. And it's a worry for us. It's a worry for the public, of course. It's a worry for our staff. It's also a worry for the judges who, like me, tend to be disproportionately old and sick. And so as a consequence of that, our experience may be different than some of the others. We made a decision early on in consultation with the other judges. We shut everything down. We have not done, until Monday, we have not done a single thing in person since the Supreme Court's first administrative order came out, or soon after it came out. Just this week, we did our first in-person out of custody criminal pleas, and that in applying the guidelines, recommendations, and requirements that Judge Munyon's group did the heavy lifting in determining how we could operate safely. But the reason I took the extraordinarily drastic step of shutting our entire court system down and making all of our staff and judges wear masks even when they're on the bench, if there's another person there, we had some nasty scares that happened at the beginning where it looked like not only would we have to shut down, but we might have so many people get sick that we wouldn't be able to operate. So that's what we did. In the end, those scares turned out mercifully not to materialize. But we had to take some really drastic action because of it. With 6 counties and all these courthouses, it's a lot of different circumstances, a lot of logistics. I've got, Tallahassee with 300,000 people, still a relatively small county by Florida standards. I've got Franklin County that only has 2 cases of COVID in the entire county. Liberty County liked to boast about being the last county in the state that had no cases, and then one weekend they ended up with 200 cases at the prison. So it's been a dynamic situation. And I'm really, really proud. I'm proud of us, but I'm mostly proud of the bar because the lawyers adjusted. I got nothing but assistance and cooperation from our bar. We have gotten nothing but constructive suggestions, much like a lot of the questions that we've gotten here. On the Zoom bombing issue and the misconduct on Zoom and muting people and all of that. So I do dependency. I wish I did business law sometimes, but I do dependency cases and domestic violence injunctions myself. I've conducted probably more than 500 hearings by Zoom since we started going remote. Very, very few problems. I have had some problems. We mute people sometimes because we do mass dockets, and I've had 40, 50, 80, 100 people in a room at one time, much like we would on a mass docket day on domestic violence day or on juvenile dependency day. And people misbehave sometimes. They interrupt and they are intrusive. They're under a lot of stresses. In those hearings, probably of the 500 hearings or so that I've done, probably had to mute people without giving them the ability to unmute themselves once or twice. It's been very, very rare for me that we've had significant problems. The lawyers, particularly in the civil cases that I've done, but in the domestic violence and dependency cases that I've done, the lawyers have been extraordinarily supportive of the idea. In dependency, I've got probably 10 lawyers covering 6 counties, and their ability to get the routine things done. Lots of what we do in court is a recording function as much as it's a decisional function. And in those routine matters, the efficiencies associated with it, the lawyers have been uniform in their support of video hearings. Well, I don't know about anybody else. I have been reluctant to do hearings by video in the past. I don't think we're ever going back. I think we'll go back. Obviously we'll open the court system again, but the efficiencies have been so obvious for routine matters for lawyers that I suspect this resource, the appellate courts have used it for remote resources much more effectively than the trial courts have for many years, as Judge May said. And I don't think that we're ever going, back. I saw a couple of questions. Are you providing masks to the staff? The answer is yes. Are you providing masks to the public? The answer is yes. Judge Munyon's guidelines require in-person hearings when you're in phase 2 to have for everyone to wear face coverings while we're in hearings. We installed the temperature taking kiosks. We installed we are providing the questionnaires, and we have staff downstairs taking the questionnaires. Of course, so on Monday we took 5 pleas. So we let 15 people in the building, counting the lawyers and everybody else required for that. Today we're doing, I think, 10 hearings in person today. But yes, we're giving everybody who doesn't bring their own mask, we're providing masks, and we're providing staff to do all of the things that are required of us. We're trying to inch toward bringing juries in. We presently have a grand jury scheduled to come in July 20th. And we decided to do a grand jury because jury selection is more controlled, requires fewer people. We think we can control it better and be safer. We still think it's going to take us at least 3 courtrooms to be able to get through a jury selection and ultimately to seat a grand jury while maintaining the precautions. And we decided that was one reason. And then another reason was because of some local things that have been going on. We really felt like that was the thing that we could do in the public interest. We've had some police involved shootings that are a matter of a lot of interest in talking amongst our justice system partners, state attorney, public defender, sheriff, police departments. We just thought that was the best way to inch towards recommencing jury trials. So that's my spiel. Mr. Hyman, I sure do thank you for this opportunity, and I appreciate the time.
Thank you, Judge. I had one last question for you before we move on. As you discussed how usually you sometimes have to mute parties when they're interrupted. However, in court, there's one point in time where it is appropriate and actually necessary to interrupt, and that's when you're required to timely interpose an objection to an evidentiary issue or otherwise. How do you deal with that need when you're dealing with these evidentiary hearings?
So the way I try to do it, the way I try to do it is, first of all, everybody can unmute themselves. Of course, the time it takes you to unmute and the communications lag, like you say, that it could affect the timeliness of the objections. When we're in an actual evidentiary proceeding, and those of you that have ever done dependency, evidentiary proceeding kind of break out without, knowing at the moment that they're going to happen. But if you're doing an evidentiary hearing, and I did a trial, a non-jury trial, 8 witnesses day before yesterday, you don't mute anybody. People got, like you said, got to interpose objections. Now that requires, and the lawyers have been great about this, that requires the lawyers to really be disciplined about taking a breath and giving an opportunity for people to participate, not talking over each other, and exercising that good professional courtesy. They've really been effective. The hardest thing that I've had to do so far has been remote hearings with translators. I've done several hearings with translators from a language called Chi, which is a language, a Guatemalan indigenous language, where we had English to Spanish to Chi, back to Spanish, back to English, with one of the translators on a remote link on a mountain in Guatemala. It's really hard. It's really hard. And you don't really understand normal human communication until you operate under those constraints. Part of it is the judge. Part of it is the host being skillful. Part of it is the lawyers, being mindful of the limits of the technology, because of course the technology does have great limits.
Thank you, Judge. Next, we have Judge Donald Myers, who's the Chief Judge of the 9th Judicial Circuit based out of Orlando.
Good afternoon, Zach, and thank you again for the invitation and from the business law section. I love the chance to be able to share a little bit about the things that are going on in the 9th Circuit. We're a fairly large circuit, 2 counties, but population of 1.78 million people, and 8 separate courthouse buildings over the 2 counties. Our largest courthouse building being a tower type facility, 23 stories high. And for us, that raises some unique challenges as we talk about moving people from outside the building and into the building and up to the courtrooms, hearing rooms, and other facilities that we have throughout the courthouse. So we have been pretty aggressive in taking on the challenge have consistent with the Supreme Court's guidance and the work group's work product, developed traffic flows, capacities for individual rooms throughout the building, tried to shift work as low into the building as we can to allow escalator access versus elevator access. And really just taken on a number of the challenges, I think, in a good way. And we made the move from phase 1 into phase 2 on June the 5th, a Friday, and have been successful over the course of the last week and a couple of days now in moving folks in and out of the building, we think in a very safe fashion. But it all comes with challenges, and Judge Sjostrom is right in that every place is unique, but we share, I think, the same common goal of just trying to ensure that folks are safe as they come into the building, that we keep it safe for them and that they feel safe during the time that they're there. And we are daily monitoring the data throughout the state to try to evaluate, and particularly our local conditions in terms of the number of cases, the percentage positives, the hospital capacities, and all of the things that are required to determine, is it appropriate for us to remain in phase 2 as we see this uptick in local conditions and throughout the state. And we'll be evaluating those things on a regular basis as we move forward. The Ninth Circuit is fortunate in that we have a lot of technology dollars available to us, and we have moved out pretty quickly on the technology issues. I would tell you we've not ever closed down the courts. The things that we've been unable to do are simply because we can't bring people into the building. And so while we have not tried any jury trials, obviously, virtually everything else has progressed forward. We've been able, through remote technology, to handle domestic trials. We've had countless numbers of non-jury trials that have come through our business court, through our civil divisions, and through our domestic divisions, and now through our juvenile divisions as well. We've been incredibly successful at moving docket calendars or calls, motions, all types of evidentiary and non-evidentiary hearings throughout the courthouse in all of the different divisions. I mean, there have been 10,000 plus type hearings that we've held over the last couple of months to continue to keep cases moving forward. It's really been kind of a fun exercise to tell the lawyers that there's no good reason for you to have an outstanding motion on a case right now. We have hearing time available, and we can get it heard and make it move forward for you. And so we're hopeful that the tsunami that awaits us is jury trial work, but that we will have caught up to a large degree on our non-jury work, as well as motions and other types of hearings. We, I think, are excited about what the technology has allowed us to accomplish. Because we have 8 courthouses over the space of the 2 counties, we've been able to utilize remote technology that is local for many people. To try to minimize travel and to do some other things we're doing. I'm like John, I'm so proud of the bar. Also, really proud of my colleagues for their ingenuity and creativity in finding ways to accomplish hearings and to make things happen. It's been so exciting to see work getting done for lawyers who I know have been concerned about their law firm economics during this shutdown. And so we're grateful to be able to provide that service to them throughout the pandemic. I'm going to jump to one of the questions that was asked, because I think it's an interesting and great question about whether the working group is evaluating the distribution of laptops with hotspots to ensure that the poor are allowed to participate as jurors. I also have the privilege of serving on one of the post-pandemic planning teams with the National Center for State Courts in Communication and Funding, together with our Chief Justice Kennedy. And we've talked about some of the challenges of funding issues for the courts, the communication issues and how we address that, but I've also worked with the National Center on remote jury trial work. And we're fortunate under Judge Munyon's leadership to be able to have a pilot project here in the state of Florida for conducting jury trials in the civil context. The Ninth Circuit is one of the venues where we'll be participating in that pilot project. And in my conversations with the National Center has already undergone some preliminary negotiations with some of our mobile carriers throughout the country. And AT&T, for example, in particular, is very interested in participating in a project that would give data and minutes to folks who need to be able to access remotely for purposes of hearings or serving on jurors or on juries during this time and thereafter. We recognize the digital divide and the challenges that requires. I can tell you locally, we're excited about looking at locations throughout our 2 counties inside of government buildings where we might provide kiosks for folks to be able to appear that would have computer equipment, good solid internet connections for them to be able to participate in remote hearings and remote trials. We think that's a good way for us to take advantage of the facilities that we have. They're convenient for folks throughout a pretty massive, more than 2,000 square mile geography, to be able to participate in a convenient fashion in the types of proceedings. For our remote project, we're prepared to offer laptops and internet connections inside the courthouse for those jurors that need to come in. They'll still have their own separate rooms and private spaces to serve as jurors during the pilot project. But we recognize that we have to bridge that gap for folks who just don't have access to the technology.
Thank you, Judge. In addition, when you'd mentioned that you guys are monitoring cases, I have to candidly admit that I first thought that you were monitoring the types of cases that had been filed. What types of trends have you seen with respect to the filing of cases in the Ninth Circuit during the COVID-19 period of time?
Well, interestingly, we have seen obviously some drop off in the filing of cases, and that's consistent across all divisions. However, we have seen some pretty massive levels of filings in our county courts. Our county court actions for small claims and regular county court have actually increased, and the types of cases that we're seeing are not evictions, which we think are coming down the road at us, but instead small claims PIP cases and a new category of case, windshield glass litigation cases in our county courts. And those 2 areas have taken off. It's as if folks took advantage of the time to wear out their e-portal through the filing of those small county cases.
Thank you very much, Judge. Hopefully we'll end up being able to visit you up in the Ninth Circuit in Disney World when that reopens as well.
We certainly welcome you and your tourism dollars.
Next, we have Judge William Thomas, who currently serves in the Complex Business Division of the 11th Judicial Circuit.
Judge Thomas, we're having audio problems. Is everyone having it, or is it just me? Okay, is there another place you can go where you can get better Wi-Fi? Or if you're on an iPhone, switch to cell?
Judge, we'll give you a minute to work through the technical issues, and in the interim, unless I can hear you better right now.
You're on mute.
For the time being, while you figure that out, we'll move on to Judge Jack Tuter, who's currently the Chief Judge of the 17th Judicial Circuit Court in Florida. He's also a glutton for punishment and is serving as the Judge of the Complex Business Division of the 17th Judicial Circuit, which is my home circuit. And I can tell you from personal experience, he's been a pleasure and honor to appear in front of.
Thank you much, Zach, and thank you for the invite to this meeting. Not sure I can add too much to what the other chief judges have said. We all were kind of experiencing the same problems when this event occurred. I think we've all learned one thing, and that is these circuits are huge. They have so many moving parts that you don't realize every day that's functioning until you shut down and can't do things face to face. So we've climbed through, I think, most of our issues. So the only thing that I'd add to what everybody else has said is we tried to get out in front of this remote jury issue before the work group was even formed. I tasked our civil division to do a civil trial, which they did. I tasked our county court criminal to do a DUI trial, which they did. And then we joined ABOTA, American Board of Trial Lawyers, to conduct a third trial, which we did. And last week we did our first kind of a mock voir dire, because included in those trials, we only did the evidence and opening arguments. And feedback, I think everybody needs to mute. All right, I'll try again. So anyway, that's kind of where we are on that. We did a voir dire with ABOTA lawyers a week ago to see how that looks. I was fortunate enough to write the CEO of Zoom, who I thought some billionaire is never going to reply to some lackey like me, but surprisingly he did, and he set up a meeting with their product manager. We had a meeting with Zoom to discuss things like the tiles on Zoom, which you can't move or make stationary, like when you're doing jury selection, to be able to see the entire jury at once. So we're hoping they're going to work through some of the things we suggested to help us. And I'm doing an actual real life voir dire with real jurors who are being summoned to appear remotely for jury selection on July the 10th. And right now I'm working on their summons and directions to go to the clerk's website to watch a brief video, but then to log on to my platform, and Judge Henning will conduct the voir dire in the case, and we're going to see how that goes. We're going to see how many people have bad Wi-Fi or trying to do this on a phone, all of those things that you normally have in the courthouse that you can fix, but remotely it's much different. So I think we're way ahead of the curve on that. To use it, I think successfully, it's going to have to be a shorter case. Maybe not a lot of documents, because the lawyers still aren't very good at sharing documents on this platform, but I must say they're getting better. We've never had any problems with people trying to log into one of these business court hearings. That's for sure. They would be bored to tears in about 8 seconds and log off immediately. But I was asked that question by the editor of the Florida Bar News. And I said, listen, people disrupt court hearings over there in criminal court every day. I mean, there's always somebody being carried out. So the idea that that's going to be an issue with Zoom, it just really hasn't come to front. But I like Judge Sjostrom and Judge Myers. This Zoom is going to stay. Driving from Coral Gables to Fort Lauderdale in the driving rainstorm, or trying to get up to Judge May's court from Martin County or wherever it might be. I just think this is a convenience and a saving expense to the clients, and a real convenience to the lawyers. And I've been very happy about what we're doing. We've done non-jury trials. We've done valuation hearings. So I'm very supportive of the platform, and appreciate you inviting me, Zach.
It's been a pleasure, Your Honor. And have you gotten any negative feedback with respect to the use of Zoom for all of these processes or procedures?
Well, an article ran in the Daily Business Review the other day about kind of lawyer behavior on Zoom. Thank God it wasn't judicial behavior. I think the lawyers sometimes, especially like first appearance or other places where the camera's running continuously, kind of forget that they're on the camera. And one of them, some lawyer had his girlfriend on his lap, and another one, some lawyer was watching some things he shouldn't have been watching, shall I say. So we do get, because our first appearance is still streamed, we get people from all over the country who watch it. God, I don't know why, but they do, from gavel to gavel. And I'll get an email occasionally about this happened, or the lawyer wasn't wearing pants, or those kinds of faux pas. But again, I think it's just the lawyers not being conscious of this, when you're sitting in a hearing for, 2 or 3 hours.
And do you have any advice in terms of best practices, dress code or otherwise, for attorneys who are appearing by Zoom?
Well, look, in the business court, I get all the guys who are, my age and up. and that I don't have a dress code issue with them. I know it's occurred in family court cases where people have shown up with a tank top or in some cases no shirt at all. And we've tried to make that known that this is a court of law, and I've done it in formats and we've done it in news releases. You know, we're still dealing with the public and they're at home and they think it's different than being in a court of law. So we've tried to get that message across. But at the end of the day, I really want to get these hearings completed and give people time so they don't have to reset these. I'm not saying it's a perfect world, but I think it's been a de minimis amount of people that have not dressed appropriately, so that we really haven't taken any serious action about it, such as canceling the hearing. I think it'd be better, especially in these family cases where they have to wait for a time to get their hearing. It's better served to get the hearing over with and worry about that later.
Thank you very much, Judge. And I think, Judge Thomas, your phone
I
your
think I'm back.
is now working.
Can you hear me? Can you hear me?
Yes, we can hear you much better, Your Honor.
All right, thank you. I switched over to my phone. I apologize to everybody for that. And I know we're running out of time, so I don't also have much more that I need to add, except to say Miami-Dade County is very excited to announce to everybody that we are open for business. The Zoom platform has provided an excellent opportunity for us to be able to conduct all aspects of court operations short of being able to do jury trials. In the complex business litigation division, we are back to our scheduling orders, we're back to maintaining our deadlines, and we are overly excited about the opportunity that has been presented to us. And because I also believe that Zoom is here to stay and something that we're hopefully going to incorporate into our operations once we actually go back to normalcy, whatever that's going to look like. It has given us an opportunity to see how things can be done so much differently and effectively that minimizes the cost and inconvenience to litigants as well as to their clients. So we're looking forward to everything proceeding, and that's all I really have to add.
Judge Thomas, yesterday when we were discussing some of the issues with Zoom, you briefly mentioned that one of the biggest differences for you as a judge is that you're no longer receiving large binders full of printed out copies of pleadings. And instead you're reading them online. And Judge May also made a comment that the way you're reading when you're looking at different things online is a lot different than the way you read when it's on paper. I can tell you my mentors at Berger Singerman used to tell me the same thing, always print out your document. But with that in mind, do you have any advice or comments to how we as litigants should revise our pleadings to make them easier for you to read, given the difference in how you're reviewing and digesting that information?
Well, yeah, and Judge May actually informed me yesterday, and I did not know this, and so I thank her for this, that there is actually studies and research on this. And actually, I believe she even told me there was a formal name for it, because I was saying it's taking me a lot longer to read the pleadings. I got to take more breaks when I'm reading the pleadings. And also, you got to have multiple windows open so that you can go from the pleadings to the exhibits. I think lawyers need to understand that this is a challenge for judges and that they have to be more succinct in their writing. Normally, I would get finding of fact and conclusions of law that may be 60 or 80 pages, and it's no issue. You sit down, you read what you need to read, and I still will do that. But perhaps the lawyers can be a little more succinct in understanding that we are processing what we read in a way that we've never processed it before. And I never read by the computer such volumes of information. I was the kind of person that had everything in front of me, binders in front of me, hard copies, when I was actually reading and preparing my order. And so I think that is the biggest challenge for all of us. And lawyers need to be aware of that. And because it's going to take judges a little longer, at least it's going to take me a little longer to get some final dispositions in light of the fact that I'm adjusting to this new form of learning.
Thank you. And do you have any advice as to how to avoid people's attention spans in multi-day trials or evidentiary hearings as to how they can avoid litigation fatigue or getting bored during these processes?
I think my system kind of froze on you again, so I apologize.
Well, so do you have any advice as to how to avoid fatigue or a loss of attention span during a long period of time for a lengthy evidentiary hearing or multi-day bench trial?
Well, I haven't found that I've had several evidentiary hearings and I've been very engaged. I haven't found them to be tedious or monotonous. I think we do have to know just to take a break, just to stand up and just kind of clear your head for just a moment. But I actually think it's easier, to be honest with you, because you sit in more of a comfort of whatever room you choose you want to be in. Even though you got to kind of find your quiet space because you may have little ones and dogs running around, as I'm looking up now and I'm seeing what's going on in my living room. I think the best advice is that I think perhaps in between each witness, depending upon the length of the witness, that may be a good time to just kind of pause and take a break. But I haven't experienced fatigue, and I've done multiple evidentiary hearings.
And Judge Tuter, I had a couple quick questions for you. First of all, is there any way for you to monitor what a jury's doing when there's a Zoom hearing to prevent the juror from looking at Google or any sort of third-party information?
You mean any different than the courtroom where they're sleeping or not paying attention? Is that your question?
Yeah, except the difference is you can see a juror looking up Google on their phone, but when they're in their house or somewhere else, you can't see what they're doing.
Yeah, we have discussed all of those issues with ABOTA. There are no good answers. The one thing about Zoom for sure is, your face is right there in front of everybody, unlike it kind of is in a courtroom where you've got maybe 25 people in a jury box. So we've discussed that and we've worried about distractions and things like that if a juror is going to conduct a trial remotely. I think it goes back to the same thing that we do in the courtroom, and that is we expect the jurors to follow our instructions. The one thing that's that of course with Zoom is an issue is that we wouldn't know is if the juror had someone else in the room. Of course, we have to forbid that, but they're on the honor system, and whether that person is somehow later participating in a conversation with the juror about the case. So we have to work through all of these things. I don't think there are any perfect answers to any of this, but when we delve into the situation where we as judges completely distrust our juries and and think that they're not following our instructions, then it's going to be a problem. But I think that the same problem exists when you send them home from the courtroom with the same instructions, that they can violate those instructions if they're prone to do it.
Thank you, Judge. And the last question before we end the program is, are judges asking for, do you think it's a good policy for an attorney to ask for a synopsis or email key exhibits to motions, or for example, setting page limits or other ways to kind of make it easier for the court to digest a lot of information?
Well, okay, so on proposed orders in my business court, I've been doing more of that because you just don't have time to read to write much. And I oftentimes will put a page limit on it, 10 pages or whatever it might be. I heard Judge Thomas, and I used to be exactly the way Judge Thomas was. I needed the binder. I needed to see the writing. I've got more adept online, I think, with the filings. I agree with Judge Thomas. It's far too voluminous, far too many cases. There's no way we can ingest all of that. So you need to give us the 5 best cases on the topic and hope that we focus in on that rather than, a notebook with 150 cases. But yes, I think I have been putting limits lately on proposed orders. And I have been making proposed orders being sent by both sides simultaneously at the same minute to me, so that one side doesn't get an advantage of looking at the other side's order before they make a submission. So there's some things we've done that we're doing electronically that we wouldn't do normally in the courtroom. And again, I think it's all for the better. We're still in a 3-month learning process, all of us judges, and we're all trying in our own way to think what works best for us. It may not be the same for everybody else.
Thank you very much, Judge. On behalf of the business law section of the Florida Bar, I'd like to thank each and every one of you for participating in this program. I'd also like to thank our esteemed panel of judges for taking the time to prepare for this program and educate us about what's going on in their courts. As we've all said, one of the things that's interesting is that the practice of law, in particular in Florida, thanks to Zoom, is starting to get a lot smaller, where we have the ability to start appearing in matters that we never would have imagined are possible. And to the extent that any of you, either as attendees or panelists, have additional questions, concerns, or comments that you'd like us to try to address at a subsequent program, I've just transmitted my email address to all of you. Please do not hesitate to reach out to me, and we'll be happy to try to address these questions or concerns in a subsequent program. And again, I would also encourage all of you to try and take on a pro bono case where possible and continue to serve the Florida Bar in an excellent way as you all have. Thank you again.
Thank you, Zach.
Yeah, thank you for